Welcome to Get Justice with Scott Elliot Smith and Michael Morris. Good morning, Michael.
Good morning, Scott. How are you?
I'm good. And you?
I'm excellent. I can't wait to get into another segment of Get Justice because I know when you get fired up, these are really good. And I think I got one that's going to get you fired up.
Well, let's see what you've got.
So I want to talk about the settling your case, and when I say that, your legal or bodily injury case. And I want to talk about the do's and don'ts because the research I've pulled, there are a lot of, I won't say they come from attorneys, but it's more like advice from insurance companies that if you can settle your case between you and another person that's been in this collision, they're kind of walking you through it, but you have to go on the web to do so. And anytime there's something on the web, it's got to be true, right?
Well, obviously it's not, but a lot of people think that.
Right. So I kind of want to get into, can you define what settling your case, bodily injury or otherwise, really means?
Yeah, let's talk about this in a general overview first. A bodily injury case from a car collision, let's limit it to that. There are usually two portions of that. One is your property damage, which you need right away, usually, to resolve. Whether you're able to drive the car away or not, whether it's totaled or not, and your bodily injury, which is completely separate, that doesn't or shouldn't settle for a while because of the treatment and not reaching maximum medical improvement. So, under that limited idea, we can talk about settling the case. We can talk about cases that are small fender bender cases, that maybe it's only property damage. And we can talk about cases where you've been tragically injured or death results. Rule of thumb, Michael, is the more tragic, the more involved, the more damage there is, the more you're going to need a lawyer. The more you're going to need a really good lawyer. If you've got a property damage claim, you're sitting at a stoplight and someone takes their foot off the brake and they glide into you, there could be $1,000 property damage to both vehicles. You can probably resolve that yourself. One caveat here: I never advise anybody to do anything like that without an attorney's advice. Some people can do it on their own without it. Some people talk to an attorney, and some people just can't do it or don't want to do it. So you can handle the property damage on those small cases like that, potentially yourself, if you know what you're doing, because there's a lot to know and not know about a property damage settlement. Bodily injury cases become very, very complex in a lot of ways. And we can go into that, Michael, today. But that's a topic that's going to take quite a few shows, to be honest.
Right. I know there's no way to kind of cut to what's the, if A plus B equals C. I know that there's a lot more to it. But I want to get back to something you just said. You said you could handle those things if you know what you're doing. If you don't know, and I would say, unless you're a lawyer, you don't know the specifics. And I wouldn't recommend, I don't think you'd recommend people would take on that type of thing to settle on their own. Let's say, for this instance, you don't know what you're doing. So you contact a lawyer, and they want to settle. If an attorney wants to settle early, is it because they've kind of looked at it and said, okay, this is open and shut? Or is it's a revenue thing? Are they going to get money from it?
Well, that opens up a whole new can of worms. Let's just talk about an example.
Okay.
In my example I gave you, where someone takes their foot off the brake and they glide into you, and they're at fault for failing to maintain an assured clear distance. Even though it was a small incident, there is damage and it needs to be paid. So now we have insurance companies involved. And anytime you have insurance companies involved, you have to watch your back, because they're not looking out for your best interest. Whether you're the person who caused it, or whether you're the person that's the result of the other person's negligence. So you have to deal with insurance. You have to look at your insurance policy. If you're the person who was struck, you have to look at your insurance policy. If you're the person who did the striking, to see what is covered. If you're the person that's struck and it's a scratch or it's a minor property damage, then you have to start with what's it going to take to fix it. So you take it to a body shop and you get an estimate. A lot of times insurance companies for the at-fault party will say, no, you've got to go to one of our preferred shops. And what that really means, Michael, is they're in some type of arrangement with the insurance company
to minimize their payout, right?
Well, That is the theory.
We're going to assume that that's the case.
That is the theory. But these preferred body shops are usually body shops that want a regular flow of business. And if they're a preferred body shop, it's because the insurance company probably went to them and said, you can do this work and I'll give you lots of work, but I better get a good deal. Now, I have seen where those numbers from those preferred body shops don't add up, and they're different than an independent body shop. So you can draw your own conclusions there. But my suggestion would be, don't go to their preferred body shop. Go to your own body shop. Someone you can trust, you know they're going to do it, and they're going to do it right.
And you have the right to do that.
You have the right to do that. And that's one of the things you may not know. A lot of people think, well, I have to go to the insurance company body shop. Well, you don't. You go wherever you want. This is your car. They're at fault. You get to do what you want to get your car back in the condition it was in before the collision.
And you don't need an attorney to know that. That's part one. I mean, you should have one.
I just told you. So you heard from an attorney.
Right.
But if you don't know that, you may not know any better.
But that's why we want to get into this, is because I don't think people understand that you are the one that, you're not at fault. So you are not in control of the situation, but this is just one step that you can control on your own and make that
Absolutely.
choice.
Absolutely. Now, there's more choices from that point forward. Let's assume the collision's a little more severe and parts have to be replaced. Well, insurance companies want to use aftermarket parts. Well, you're entitled to factory parts. You bought a factory car. It's got factory parts on it. You have to insist on factory parts. Aftermarket parts, not as expensive. May not be as durable. May not wear as well. Most people don't know that. I always demand, when I do the negotiation for my client, I want factory parts, if at all possible. Maybe some cars are so old you can't, but if you can get factory parts, use those. They're better quality. That's another thing most people don't know.
So those are those are big, and that's just the beginning of it. That's just to assess what's wrong with your vehicle.
Exactly right. We're not even talking about bodily injury at this point. We're talking about car damage.
And can you, again, aftermarket parts, just kind of give someone that if they're hearing that term, they're driving around, they don't really know, define what you mean by that.
Aftermarket parts are any parts that are made by a company that's not the company that made the car. For instance, you're driving a Ford, you want a Ford part to replace a Ford part. There are companies out there that say, well, oh, we can make the same part and it's cheaper. Probably they do that because it's not as good a quality. Right. That's an aftermarket part. Or
and that makes sense. So let's take it up. Let's escalate a little bit. We're out of the body shop part. So now we're into bodily injury.
Well, there's a little more to the property damage. We're on it. We should probably finish this. So what happens if your car is substantially damaged and they had to replace a lot? Say your car's worth 20 grand and you got 7 grand damage in it. And a lot of things have to be done. Say some metal had to be rebent to get it straight again. Well, we all know this, Michael, that they can fix it. It looks good as new. But when you go to trade it in or sell it, guess what's going to happen?
Oh, they're going to knock it down because it's been in a wreck.
They're going to know because they're going to do their Carfax check or whatever background check on that vehicle.
Salvage title vehicle now.
Well, not necessarily salvage title. That's only if it's totaled. But if your car's fixed and they didn't total it, now you've got a car that's been wrecked and fixed. And when you go to trade it in, they look at that VIN number and they're going to know the history of that vehicle because anybody that does work on it will report that VIN number of what they did. So the dealership or the person who's going to buy it from you off the street is going to say, wait, whoa. This car was wrecked. You had $7,000 worth of damage. You want X dollars for it, I'm going to give you X minus dollars. So now what you have is called diminished value. And this is the case that I created. Well, this is the law on a case that I had that was solidified in Ohio, that after your car is wrecked, after it is fixed, after you're driving again, you have not been made whole yet. What you have is diminished value of your car. And it's just the example I just gave you. In other words, they fix it, looks good as new, but you go to trade it in, you go to sell it, and they are discounting that price because it had been wrecked. That's the diminished value. So what you do then is, if you've got a substantial property damage claim on your car and they've paid it, you want to, before you sign any paperwork, get the diminished value. They're going to argue with you about it because they're insurance companies and they don't want to pay you more. So you may have to hire someone. There's a company out of Akron called Vehicle Information Services you can call. You can spend a few dollars. They will look at your vehicle and they will tell you the diminished value of your vehicle. That number you use, take it to the insurance company, the at-fault party, and say, you also owe me this. And they'll argue with you, and you'll debate them with it, and they'll act like they don't know what you're talking about, but you're hearing it from the man whose case created this law, and it is there, and it is in Ohio, and you can get more money for your loss.
But they're not going to bring it up to you. You're going to have to know it exists.
Absolutely, they're not going to bring it up. Why would they bring it up? Because they don't want to pay more money. Insurance companies are in the business to make a profit. And a couple different ways they make a profit is get your premium checks, and then they put in the market, and they make interest off of that. How they lose money, one way, is paying claims. So they institute huge divisions within their company how to not pay a claim. So if you don't know what your rights are and what property damage claims are available to you, they're certainly not going to offer it.
But, and again, we addressed this on a show a few weeks back where somebody showed up the day after my accident to write me a check for a car that I thought I was getting away with murder because the car wasn't worth that when I bought it. But the future bodily injury claims and all that, it all went away because I signed off.
Well,
I thought, I'm really getting away with something right here.
Yeah, now there's a difference when your car's totaled. Now, if your car's totaled in the collision, there's no diminished value. You're entitled to fair market value of that vehicle prior to the crash. So what do? You go look up NADA, you look up Blue Book, you go to a dealership, say you want to go buy an identical car. What's it going to cost you to buy that identical car if it was totaled? Well, the dealership's going to tell you, hey, I'll sell you this car for X. Well, you go to the insurance company and go, look, I looked up NADA, I looked up the Blue Book, I went to the car dealership, I found the same car, I want the same car, I love that car, this is the price. And they're going to go, no, we're not paying you that. Well, that's the fair market value. You have to pay me that. No, we don't want to pay you that. So they're going to tell you that they hired their own appraiser. Insurance companies have in their back pocket appraisal companies who want to come in and say, oh, no, your car's worth much less than that. Well, fair market value is fair market value. A lot of times you can call them out and say, look, you bring me that car at that price and you can pay that price. But the car I found at a dealership is a different price, and that's fair market value because they won't give it to me until I pay this number.
Well, insurance is supposed to make you whole. So if something damages your property, you should get that same thing back. That's what it's about, right?
Absolutely. You are to be made whole. And any type of collision, any type of injury that's caused by someone else, the law says you are to be made whole. On a property damage case, it's a lot easier. When you get into bodily damage, now it becomes tricky. That's when you better have an attorney.
Well, before we go to bodily injury, I want to finish this part. So, when this is a part that you would need an attorney for, though, right?
You are, but it's very difficult to hire an attorney for property damage because usually attorneys take these on a percentage, and it's not really fair to the client to take a percentage, and otherwise you can charge them by the hour. Well, that can get expensive too. A lot of times what I do is I walk people through the process. It's free, and then they go do it. Hopefully they'll call me in the future on a bigger matter.
Right, but that's my point being, if you don't know the law, you've got to find, we always say you need a doctor and you need a lawyer that you can go to, and you need an accountant, right? Those are the three things you need in life. We say that all the time for this very specific thing. If I was to get into an incident, whether it was car related or not, the first call I'm going to make is you because at least you know you've heard of this or can point me in a direction. If it's property damage, I would want to know an attorney that could protect me somewhere down the road. Maybe you're not charging for it, but you need some kind of guidance. You need an expert.
You do, and it puts you in a hard position as the person who needs the advice, and it puts the lawyer in a hard position because what you're looking for is free advice. And Abraham Lincoln said it best: a lawyer's time and advice is his tool and trade. You go to a doctor, you pay their bill. You go to an accountant, you pay their bill. But everyone wants to call a lawyer and go, hey, give me the answer for free. Well, for 35 years, I've been doing it. And it's difficult. But that's what people want and expect. But it's still a valued service. So I try to talk people out of hiring me on those small property damage cases. But I will give them some advice. So get them through it. what we're talking about here today.
I was just going to say, the reason we do the show is we are giving some free advice, and it's worth your time.
Well, I haven't given the whole story, so if you need an attorney on a particular instance, call an attorney and get the advice of the attorney on your particular facts. Not all of my advice fits every fact pattern.
Okay, I promise we're going to get to bodily injury, but let's take a break here. You're listening to Get Justice with Scott Elliot Smith.
How many minutes we had on that?
15.
15, I cut up right in the middle.
Yeah, I wanted to get right to 15 so we can get that monitor. So, why don't you bring us back? We'll talk about, but I really want to get into bodily injury now. Unless,
easy peasy, lemon squeezy.
Okay, I thought you know about it. So bring it back, and I'm just going to throw it.
I'm going to bring it back. Hold on.
These stars and their deep attitudes. I need my water.
You gotta take a drink.
How's my hair look?
I know.
How's my hair look?
I'm just harassing him.
How's the bald spot? Is it shiny?
You can't see it from here.
Okay.
All right, let's go.
Ready?
Yep. Welcome back to Get Justice with Scott Elliot Smith and Michael Morris. Michael, you were chomping at the bit.
I know. I was jumping the gun several times because the bodily injury part, that when we were talking about, the topic we're talking about is settling your case, doing it on your own or retaining a lawyer, the do's and don'ts. Bodily injury. You're an expert in this. 34, 35 years of doing this. Get into why you need an attorney for a bodily injury case.
These cases are difficult, and if the attorney that you choose doesn't do this almost exclusively or limit their practice to it, as we're required to say, you probably have the wrong lawyer. This stuff seems easy, and lawyers think they can do it, but if they haven't done it for a while, they don't have a proven track record, and they don't do it almost as a limited nature of their practice, they're probably not for you. So you have to decide who you're going to hire first. In the bodily injury cases that we handle at my firm, we're very selective. We handle very difficult, very high-end, if you will, very tragic instances of conduct cases. In other words, people that are injured very badly, people that die as a result of a collision, and sophisticated issues of engineering, accident reconstruction, biomechanical issues, medical issues, proximate cause issues, permanency issues, disability issues, all come into play.
So that's just a few things that you can't do on your own.
That's just, well, no one could do these on their own. There's a lot of attorneys that would have a tough time doing this on their own unless they limit their practice to it, because it is very sophisticated. As a lawyer, I have to learn different professions. I have to learn engineering. I have to learn medicine. I have to learn biomechanics, because I'm dealing with experts who are hired by the insurance companies and trucking companies to oppose my experts to show how much fault there was, what the person should have done, how that collision could have been prevented, the energy imparted between the two forces, and the energy that was imparted, what's called the delta V, caused the type of injury that was sustained. Because a lot of times they fight you on everything. It wasn't our fault. If it was our fault, your guy was at fault. If your guy was at fault and we were at fault, he already had pre-existing injuries. If he had pre-existing injuries, we didn't cause the injuries. If he had injuries at all that we caused, they resolved. It's kind of the mantra for insurance companies. That's kind of, I gave it to you in the thumbnail sketch, but they always are looking for, it's not our fault, it's not our fault, it's not our fault.
So it's like a layer cake, and you have to keep digging
oh my
down
gosh,
to the base.
And the more you dig, the more you find.
So in that case, you have, or I don't mean to say case, in that example, you have to have experts that you can call on, or you have to read the law. I know you and Nick, shout out to Nick today, but you were talking about a case the way it was worded. You guys told me how long you spent trying to determine what this meant for one specific case. It's not something you can play around with.
No,
you have to have an expert.
a lot of people like to try to make the law black and white, and in some instances it is black and white, but in most instances it's different shades of gray. So there's not just one answer. That's why you have lawyers. That's why you have cases that come out that interpret statutes or laws, and you have regulations, and you have rules. And the trucking industry is controlled by the Federal Regulation Safety Act that has their own set of rules. So guys that drive, professional truck drivers that drive commercial vehicles, have a different set of regulations than you and I driving a passenger car.
What would be examples of that?
Oh, perfect example is the weight of your vehicle. For instance, if you are an over-the-road truck or commercial vehicle, you have got to keep a log on how much you drive your truck. And you can only drive it so many hours a day and so many hours over a period of time before you're in violation. Because what they don't want, Michael, is, as you would expect, people falling asleep at the wheel.
Right.
And it happens. And trucking companies don't always give their truck drivers a fair shake to get their job done. So it sometimes causes drivers to have to drive over the limits, violate those federal regulations, fall asleep, cause collisions, and death. I've got several cases like that.
Well, I was gonna say the logistics. If you're going from Columbus to Arkansas and you only have X amount of hours, you're gonna get behind a traffic accident. You're gonna get stuck somewhere. You're gonna fall asleep because you're tired. You're still gonna make it by that amount of time.
Well, you're at the mercy of the trucking company. Unfortunately, you're also at the mercy of the federal regulations. So you take a risk of violating that law on how much you can drive, how long you can drive, versus getting that load there when your trucking company wants you to. In other words, it's almost as if the trucking companies are encouraging you as a truck driver to violate those rules. And you're sitting there looking, going, well, I can violate the rules or I cannot feed my family. What am I going to do? So it puts truckers in a bad situation. But when in doubt, follow the regulations, because the last thing you want to do is fall asleep and kill somebody.
But what you said before is there are lawyers on the other side that will say, well, this happened because of this, and you, on your side, have to kind of pick that apart.
You do. Let me take us back to where we started this, about settling your case, because a lot of things have to go into settling your case. One thing I tell everybody that comes in my office, regardless of the kind of case, there's about 4 factors we have to look at. Number 1, fault, liability, and comparative negligence. In Ohio, there's comparative negligence. You cause a collision with me, there's 2 parties involved. There may be something I did wrong. You may have struck me at an intersection, but you may have said, I got the green light, and I may say, I've got the green light. Or their jury has to then determine, based on 100%, who's more at fault. Is Mike more at fault, 60%? Is Scott at fault, 40%? Is it 70-30? Is it 100-0? Okay, that's the first thing, liability. Second thing is proximate cause. So if you're at fault, what did you cause? What did you cause? You caused me property damage. You caused me injury. You caused me all kinds of grief, pain, suffering, loss of wages, loss of medical bills, and it goes on and on. That's number 2. The third is damages. What, in fact, has happened to you? We have economic damages that we can see. Your lost wages is something we can feel, we can touch. Your medical bills, we can feel, we can touch. What about non-economic losses? You can't use your left arm. What's that worth? Settling your case is hard. And the last thing is collectability. So this is where insurance comes in. And I want to tell everybody who has not listened to this show before, if you're driving a car and own a car, you need uninsurance and underinsurance. And if you don't know what that means, it's this. If someone hits you and they don't have any insurance, or they don't have enough insurance, and in your example where you can't use your arm, and they've got very state minimum limits of $25,000, you better have you coverage, because you're not going to collect. And then what's going to happen is you're going to become a ward of the state, and then we're all going to pay for you, Michael, because you can't operate and function. Now, I'm saying as an example, not necessarily your case, but in your instance, if you can't use your arm and you need your arm to work, and the person who caused the collision has minimum limits, and you don't have you coverage of at least $100,000, you're not going to have any money. And then what you can't do is work. And if you can't work, you can't pay your bills. If you can't pay your bills, you're not going to have a place to stay. And then you're going to be on the street. And then you're going to homeless shelters, or you're going to get on welfare or governmental assistance. And then guys like us will have to pay for you. So what I want you to do is protect yourself. And you coverage means uninsurance and underinsurance. If they don't have enough insurance, they have no insurance. So at least they get as much as you're worth in your mind, and make that equal to your liability limits. So that's the 4th thing: liability, proximate cause, damages, and collectability. So you may have the worst case in the world. You may come to me and you may not have enough insurance. Trucking companies are different. They have layers and layers of millions and millions of dollars of insurance. So they usually have enough coverage if they hurt you bad or kill you.
Well, again, the underinsurance part, and if you haven't heard this, go get it. It costs next to nothing to have this. But that's how we kind of started all these things. If you have that, and then you get into property damage, you're better off. So
Right.
we probably should have said, get your underinsurance first. Now we're going to go into property damage.
Always get your, call your agent if you don't have it. Ask them to quote you out your uninsurance and your underinsurance. Get it at least equal to your liability limits. I hope your liability limits are at least $100,000. It sounds like a lot, but the premiums are not necessarily that high. And you get U coverage with it. I call it U coverage, uninsurance coverage. It's not that much more. You've got to do it to protect yourself from those out there who are not looking to protect you.
Right. Well, I think, and again, we just scratched the surface on property damage, but again, this is a very important thing. The biggest thing was this was supposed to be the do's and don'ts. Don't try to settle a bodily injury case. If it's a fender bender, it's okay. We have an attorney that will say, if you can handle those on your own, that's good.
Potentially, yes.
Potentially.
But it depends on the case.
So is there anything else you'd like to say before we sign off this week?
No, I think settling your case has so much intricacies to it, Michael, that we need to pick this up on another show.
And we will.
Thank you for listening to.
Oh, okay.
That's
Sorry.
fine.
And we will, and you guys had a huge pause.
No,
Okay.
I just gave
He was giving me the.
Oh, okay. Go ahead.
You've been listening to Welcome to Get Justice with Scott Elliot Smith and Michael Morris. Thanks for listening.
Or you've been listening to Get Justice.
What'd I say?
Well,
You've been listening to Welcome to Get Justice.
All right, maybe we should try that one again.
Okay, go ahead.
You've been listening to Get Justice with Scott Elliot Smith and Michael Morris. Thank you for listening.
All right.
I heard about that. I was having a stroke because I'm like.
I'm
"Did
looking
you
at
say
my
what?"
paper and
No,
seeing
I got
the
it.
words, and I'm reading the
got it.
damn words off the paper.
That was awesome.
You've been listening to Welcome to Get Justice. When did you start calling it that?
I literally thought, did I just